Hi, my name is David Jenkins, and I'm a wealth advisor at Elevate Wealth Advisory. Today's topic is the Secure Act 2.0, which is new legislation that was signed into law at the end of 2022. It's called 2.0 because it is a revision to the original Secure Act, which was passed in December of 2019. Secure stands for Setting Every Community Up for Retirement Enhancement. So both of the Secure Acts mainly address the rules and regulations surrounding how to contribute and withdraw money from your retirement savings accounts. The Secure Act 2.0 is a very broad piece of legislation, so we have divided these videos into 3 different sections. My focus today will be on the planning issues to consider arising from changes that are effective for this year, 2023, but there are 2 other videos that will address the changes coming in 2024 and 2025 and later. So I'm going to share my screen. So to begin, you should see a handout on my screen. I will start at the top left of the page and cover the highlights. If you would like a copy of this handout, please reach out to us and we'd be glad to provide one. Okay, so let's zoom in. Okay, so starting with what you should consider from a planning perspective for the changes that are effective for 2023. I'm going to begin with a topic that usually garners a lot of interest, and that is required minimum distributions, or RMDs. Remember that an RMD is the age that you're required to start withdrawing money from your traditional IRAs or retirement plans, such as a 401k. So the IRS gave you a tax benefit for tax deferral and gave you a tax break, tax deduction when you contributed money, but eventually they want to get their tax dollars on those monies, and so they require you to distribute money from your accounts, and this is RMD. So the original Secure Act of 2019 increased the RMD start age from 70 and a half to 72, but this most recent update again increases the RMD age. If you were born between 1951 and 1959, your RMD will now begin at age 73. Effectively, this means that no one will have to start RMDs in the year 2023, as those born in 1951 will be turning 72 this year. However, if you were born in 1960 or later, your RMD will begin even later at age 75. So this is starting 10 years from now in 2033, the RMD age will move to 75. And remember that if you've already started RMDs, like say if you turned 72 in the year 2022, then you must continue them. This just raises the beginning date for those who haven't started their RMD yet. And again, this applies to when you are forced to take money out of your retirement accounts or your traditional IRA, not necessarily an inherited IRA. The RMD for inherited retirement accounts is different. But this is very important for a few reasons, as it gives you additional time to implement tax planning strategies such as Roth conversions, harvesting capital gains, or accelerating taxable distributions. The result of delaying the start age of your RMDs means that those RMDs will be even larger and have more of an effect on your tax situation. So, when from a financial planning perspective, the way we look at taxes is, yes, if we can save you some taxes now, we want to, but in the bigger scheme of things, we want to save you as much over your lifetime. So we want to minimize the amount of your wealth that's lost to taxes over the course of your lifetime. And so this additional time with the RMD age being pushed back gives you a lot more time to implement some of those strategies. I should also note that the qualified charitable distribution, or QCD, age remains at 70 and a half. Lastly, on RMDs, again, they reduced the penalty for missing an RMD from 50% to 25%, with a further reduction to 10% if you quickly correct the mistake. And I'm sure that they will provide some clarification on what they mean by quickly. The next thing to think about is if your employer offers a match on your retirement plan contributions to something like a 401k or a 403b. If so, you now have the option to elect to receive those matching contributions as Roth. Before, even if you elected to have all of your personal contributions as Roth, any matching contributions had to be made pre-tax. One nice thing about this is that all employer contributions treated as Roth will be immediately 100% vested. And the reason for that is a downside to this is that the employee or participant, you, are responsible for paying the income tax from the employer's Roth contribution. So it will be included in the employee's gross income for the year. This could potentially create a liquidity crunch if the employer contributions are significant, as the employee won't receive any extra cash to pay the tax bill, and taxes aren't automatically withheld, like say with a paycheck. So if you contribute $6,000 to your 401k and your employer matches that with $6,000, if they match with Roth, then you will have an additional $6,000 added to your taxable income at the end of the year. And although employer Roth contributions can start immediately, it will take some time for employers and administrators to catch up given the other sweeping changes in Secure Act 2.0. So it'll take some time for plans to digest these new provisions. So even though you have the ability now, it's will take some time to get the systems implemented. Moving on, and again, this has to do with Roth retirement plans, is that you're now allowed to make Roth contributions in a STEP or simple IRA. Before, you could only make pre-tax contributions, as STEPs and simples couldn't accept Roth funds. Now, for tax years starting in 2023, so now, both SEP and simple IRAs can offer Roth options. The IRS must still pave the way for this by issuing additional guidance, though. But then employers need to update plan documents. So again, it may take some time to truly be in effect. I should note that, like with a Roth 401k, employers are not required to offer that option to their employees, but they can now. So it's not necessarily a requirement that they offer you a Roth simple, but they do have that option. Okay. So the next few bullet points have to do with accessing funds from your retirement accounts in an emergency, as the Act really enhanced the ability for employees to extract money from their retirement accounts before retirement for certain hardships. So are you a public safety worker, including private sector firefighters and state or local correctional officers? And do you need access to your retirement funds early? If so, you may be eligible to access your funds penalty-free if you're over age of 50 and separating from service. If under the age of 50, you may still be eligible if you have at least 25 years of qualified service to the same employer before separating from service. So I know I've had some clients that are, right out of high school or college, they became firefighters, and then once they reach their pension age, sometimes they move on and have encore careers. And so a lot of times they do end up doing this before they turn 50. And so you would be, in that instance, you'd be eligible as long as you reach that 25 years of qualified service. And so what they're talking about, if you recall, is that to access funds from your retirement accounts or from like an IRA without having to pay a penalty, early withdrawal penalty, you have to be age 59 and a half. And so this gives you 9.5 extra years if you're a public safety worker. And again, having to do with emergency funds, if you are terminally ill and need access to your retirement funds early, you may be eligible to access your funds penalty-free, regardless of age, if your doctor expects you will pass away in the next 7 years. So that's how the Secure Act 2.0 is defining terminal, is 7 years. And lastly, having to do with hardship withdrawals. Do you need to take a hardship withdrawal from your retirement plan, and is the timing urgent? If so, consider requesting the withdrawal from your employer via the newly allowed self-certification. So it means no evidence is required in order to expedite the process if adopted by your employer. So be mindful to document your evidence in the event you're audited. Again, this is one of those things that it's very new, and plan sponsors and employers are trying to play catch up. And so they will have to implement the processes for this. And lastly, is giving to charity part of your financial planning goals? If so, consider whether making qualified charitable distributions, QCDs, to a charitable remainder trust or charitable gift annuity makes sense for your situation, but be mindful of the associated limitations and costs. Again, the QCD age remains at 70 and a half, even though the RMD age was 72 from 2019 to 2022, and then now it's moved to age 73. So again, these are just some of the main changes coming out of the Secure Act 2.0 that will take effect this year in 2023. But please don't forget to check out our other videos about the Secure Act 2.0. Thank you very much.